the director of the Tulane Law School Sports Law Program and the man who conferred an unsigned honorary degree on me, Gabe Feldman, here on The Rich Eisen Show. How are you, Gabe?
I'm good, Rich. How are you?
I am doing fine. We'll get to that unsigned document in a moment.
It's not binding.
Okay, counselor, we'll get to that in a moment. So when you read the 19-page ruling by the commissioner, what did you think of it from your legal eyes, knowing that groundwork was clearly being laid for an appeal that would be expected from the Players Association in a federal court?
Well, this groundwork has been laid since day one, since I hired Ted Wells to do that independent investigation, to issue that several hundred-page report, and then delegated the initial decision to Troy Vincent. This has all been with an eye towards ending up in federal court, and here we are. And obviously the league has learned a lot from not only the Adrian Peterson case, but the Ray Rice case and Greg Hardy and Bounty situation before that, that in this case, of all cases, Roger Goodell has to make sure that this case holds up in court. Because if he can't, as the commissioner, pursuant to the collective bargaining agreement, have final say over conduct that impacts the integrity of the game on the field, then he has no rights anymore as a commissioner over player conduct. This has got to be the case he can win, particularly given that he's not acting as investigator, initial judge, and then appellate judge. He's only acting as the final appellate judge. So I think this is, that 19 pages, the several hundred-page Wells report, this is all designed to make sure that the commissioner has a right, as they thought they collectively bargained for, to have final say over things involving players that impact the best interest of the game.
So what is Don Yee, who's Brady's agent and also, no doubt, legal counsel, personal legal counsel, and what is Jeffrey Kessler thinking? What are they trying? What is their plan right now, do you think, Gabe, legally?
Well, they've got two plans. We know the plan all along, after they didn't get this right from the commissioner in the 2011 CBA, was to try to get it back from them, try to figure out some way to hack away or chip away at the commissioner's power, and they've tried it at every turn. That's why we're seeing so many challenges, and the irony that the commissioner wanted to hold on to this power over the players, and yet he's the only commissioner. This is the only league where these cases end up in court. So if he had actually given up the power, then we wouldn't be ending up in court. But I think Don Yee and Jeff Kessler and the PA is thinking that although they did agree in the CBA to give the commissioner these rights, he still has to execute these rights in a fair manner. And that this is there's been prejudgment, there's been bias, it's not a fair process, there's not enough evidence, and all the arguments you've heard over and over and over again. And I think fundamentally, beyond just trying to wrest the power away from the commissioner, they believe that Tom Brady and the other players aren't treated fairly when the players have no notice of what the possible punishment can be. And I think they take extreme issue with the fact that the commissioner, from their perspective, is making this up as he goes along. And there's not a set schedule. You can say, if you do X, you get punished Y. Instead, it's just up to the whim of the commissioner. And that, they would argue by definition, is arbitrary and capricious, which then allows the federal court to do something very extreme, which is to overturn the commissioner's ruling.
Tulane Sports Law Director Gabe Feldman joining me here on The Rich Eisen Show. So explain to me why the Players Association and the league have filed in different courts. Walk me through the process on that, Gabe.
Yeah, as we know, and Albert talked about before, Minnesota has a reputation of being NFL player friendly. Under the previous installments of the collective bargaining agreement, any dispute under the CBA actually had to be filed in Minnesota. So most of these cases went to Judge Doty, and in many cases, Judge Doty ruled in favor of the players. And then even beyond Judge Doty in 2011, remember during the lockout, Judge Nelson, district court judge, enjoined the lockout very temporarily. That got quickly overruled by the Eighth Circuit. But in the Adrian Peterson case recently, Judge Doty came back and reversed the NFL suspension. So the players certainly think they're going to get home field advantage by being in Minnesota. I think the league wants to be probably anywhere other than Minnesota, except maybe also Massachusetts, the idea that Tom Brady might have home field advantage there as well. And they just think New York has been relatively league-friendly in the past, not only to the NFL but to other pro sports leagues. And they have an argument that it makes most sense in terms of where the parties are, where the witnesses are, where it would be more convenient to have the hearing. That certainly Minnesota doesn't make sense in terms of convenience.
So using the vernacular du jour, both sides like their courts a certain way, is what you're saying, Gabe.
They both like their courts a certain way. They both think they can get home field advantage. I don't know that anyone's piping in crowd noise, but certainly I think the league and the PA think this case may be decided based on where it ends up.
So
Minnesota.
So is that the first legal shot fired in this? How does that get decided where this winds up?
Yeah, there's no question this was the first legal shot. And the NFL, again, they've been waiting for this moment to happen, and so they had their papers ready to file. And that 19-page opinion by the commissioner was basically a filing to the court. And they filed first in New York. Their argument is that whoever files first gets to have the case heard there. The players are going to say that filing, and you've heard this word before, is a sham, and it's designed to manipulate the system, and that the players are the one, the Brady's the one who's aggrieved here, and he gets to choose where the case is heard. And so there are going to be motions filed back and forth in New York, and assuming the players file in Minnesota, and we're going to have a judge make that initial decision, which is, as we know, the wheels of justice turn slowly. This is going to make them turn even more slowly because that's going to have to be the threshold decision, is who actually gets to decide this case.
But for Brady, those wheels have to grind faster than the start of the season. Correct, Gabe?
They do, and the only way you speed up the wheels is if you file for either some temporary relief, either a temporary restraining order to block the suspension or, more likely, a preliminary injunction to try to get him back on the field for week 1 while the case plays out in court, and then hope you eventually win in court. Because if you lose in court or if you lose on appeal, then the suspension kicks back in, and then the question is, well, instead of weeks 1 and 4, is it at the end of the season, or maybe it's even into next season? And I'm sure you guys have talked about the StarCaps case with the Minnesota Vikings back in 2009. That initial suspension was handed down in 2009. There was an injunction granted all the way to 2011. By the time the suspensions kicked back in, one of the suspended players had already retired. So there's a lot of incentive for Tom Brady to slow this down as much as possible, assuming he gets the injunction, but that's a big assumption.
So now let's. I'm on the phone with Gabe Feldman, director of Tulane Sports Law. So who decides which court this gets heard in? And is that the same person that Brady is going to try and get that temporary relief so he can play week 1 in? Gabe.
Well, the players are going to file for a motion to transfer the case, and then there's going to be a jurisdictional battle. And so it may be that the New York case decides that it doesn't make sense to hear it in Minnesota. The Minnesota court might decide that it makes more sense to have it be heard there. So that's going to be up for those judges to decide. And it may be that judge is the one who decides the preliminary injunction, or it may not be. There may be a different judge assigned to the case.
My head's going to explode, Gabe. I got to be honest with you here.
We're only on day 1.
I know. Well, so how long does this play out? I mean, because, again, September 8th, clock's ticking. I mean, Tom Brady wants to play in that game. We all know the Patriot fans would love to see him be out there week 1, and then NBC will show him on the field and the commissioner in the stands, and presumably he'll be there, and then, you know, Robert Kraft also. Walk me through how this plays out and how quickly it can play out, Gabe.
Well, I assume the PA, through Jeff Kessler, are going to file for an injunction today and try to get that case heard in either Minnesota or Massachusetts, wherever they decide to file. Presumably it's not New York. And then they can have a hearing on the injunction very quickly. That can happen in a matter of days, potentially end of the week or early next week. And the injunction could be granted in a matter of days. So he could be back on the field before week 1, and we could know that within a matter of a couple of weeks. But again, that's just the beginning of the process, because as we saw, and I hate to bring up bad memories for you, but as we saw back in 2011, even if the district court judge grants the injunction, whoever loses that is going to ask for a stay, an immediate stay, to say, no, you can't grant the injunction yet because it's going to harm us, whoever the losing party is. And then we've got to have a hearing on that. And then that can be appealed. And then we've actually got to go through the actual trial. And then even after you have a trial, that can be appealed. So if we're talking about start to finish, we could be talking about a matter of years. As far as Brady is concerned, the key obviously is getting that injunction, because if he gets that injunction, he gets back on the field, then it really doesn't matter how long it takes. And it's actually in his interest to drag it out even longer, because if it takes 2 or 3 years, then again, he may not be playing anymore. Then it's not as big of a deal. If he doesn't get the injunction, then this really could be over very quickly. This could be over by week 4, and then all he's doing is suing for damages. And then the focus really shifts away from the case, because I don't think anyone really cares much about whether Tom Brady will get his salary back. They want to see if he's back on the field for weeks 1 through 4.
So I've got a couple questions for you about, let's say we do get to trial, and obviously we'll have you back on before that anyway, but let's say we do get to trial. A couple things that I'm wondering about. The cell phone that Brady didn't want to give up and says that it would have been unprecedented for me to give it up. I don't have a right to give it up. Would that have to be placed into evidence, or the subpoena power of the court get the information that supposedly doesn't exist anymore according to Brady's wireless provider? Gabe?
It could, but the league would argue, and this actually could work into Brady's advantage in not having that subject to discovery. The league would argue you shouldn't even get there. That it's not the role of the court to re-examine the evidence, to second-guess the commissioner's decision. That's why we have final and binding arbitration. That's the purpose of this provision of the collective bargaining agreement, that it's cheaper, it's faster, it's more efficient. You don't need to run to court every time, and you can't run to court every time. Unless there's some egregious error, unless, again, the commissioner showed that he was biased, or the process was completely unfair, or there's just no rational, reasonable basis for the suspension. I think it's a long road to get to Tom Brady having to turn over his cell phone. If it gets to the point where the judge says, I need to look to see if there was sufficient evidence, or if there was any evidence, then we could see some subpoena power come in and Tom Brady have to turn over those cell phone records. But that's a really long way down. And if we actually get to that point, then that's probably a good sign for Tom Brady in terms of potential success of the case. If the judge is willing to look that closely, the league's going to argue he shouldn't even get close to that because you have to give almost complete deference to the commissioner's decision.
And what about Bob Kraft being so upset about this? Does the Players Association at all, can they use Bob Kraft against the commissioner? Could that possibly happen in this case?
I think they can try, but the public comments that people make in the heat of the battle aren't going to have too much impact on a judge. We're not going to be talking about a jury in this case. I don't think a judge is going to be particularly swayed by that. I think a judge might be swayed by the comments we've seen or alleged comments we've seen from other owners pressuring the commissioner to uphold the suspension, because then you can argue that Brady didn't get a fair hearing. He got a hearing from someone who had been pressured by the other owners who were obviously in conflict with the Patriots and Bob Kraft. So that might be a stronger argument. And that's, again, part of the central argument that that Brady has to make anyway, is that this was just an unfair process, and here are the 15 reasons why the process was unfair. We're not contesting the fact that there is a collective bargaining agreement that gives the commissioner this power, but he has to execute those powers fairly. We're entitled to a fair hearing. We did not get that. Okay,
so let's wrap this up. Does Brady get an injunction, do you think? Does he play opening night? Does he have a good case for that, Gabe?
Well, I'll use Ted Wells' words here. I think it's more probable than not that he is not playing. I think it's more likely than not that he serves that first game, really for two reasons. One, again, it's rare for courts to overturn commissioner decisions. They want to give deference. They've got to find that there was something wildly egregious about the decision, and that's intentional. That's not just with the commissioner. That's with any arbitration. So that's already an uphill battle. And then, in order for him to be on the field for week one, he's going to have to get that injunction. Courts refer to injunctions as drastic and extraordinary remedies. They don't hand them out very often, because not only do you have to show that you're likely to succeed on the case, which is already an uphill battle, but becomes a steeper climb because you have to show you'll be irreparably harmed if you're not allowed on the field. So Tom Brady's going to have to show that he's going to win the case, but also that he can't be made whole for missing those first four games.
And based on what you've seen and heard and read, does Tom Brady have a quality case to get this overturned in federal court, period, end of day?
At the end of the day, again, more likely than not that the status quo remains. That this will be a tough battle, but this is going to be a tough one for the league to lose.
Gabe, I really appreciate it. Please sign my honorary degree if I send it to you. Will you please do that?
You can just forge it. I'm sure that'll do that.
Wait a minute. I don't want you disbarred over this, Gabe.
Oh, that's all right. I'll send you a new copy. Let's do it that way. Just you can cut that part out of the
Okay. We'll chat soon, Gabe. Thanks so much.
Thanks, Rich.
You bet.
The Rich Eisen Show, weekdays at noon Eastern. On Audience.